Sir, Noah. Oh, you too, Bob.
Tomorrow night, as of every Tuesday night, the Dirty River River Show will be playing at the Howler Wolf Den. $5 for the student ID. Come and get some burlesque and booze. A good time.
Whoa.
See you there tomorrow night, 9:30.
That doesn't sound very Catholic.
No, it doesn't sound Catholic at all.
You have to be 21, I think. They lowered the drinking age. Of course not. So who else? Any other announcements? Yes, sir.
What's up, everybody? It's BK again. I went and posted out flyers for the school where you can go and get my music. I also invite everybody to go on YouTube, check out OVA, me and my boy in Kansas City. Speaking of music, all the good, so y'all go check that out.
Thank you so much. Anybody else? Sir.
My name is John Paul. I play in a power bluegrass trio called Mississippi Delta.
Of course you do.
We have a show this Friday at 6 and a show 22nd at 10.
Thank you, Joe. Anybody seen our music news on the site? Y'all see that? You should check it out, cfmae.org. You can see the music news. If you want to participate, you just see Hillary. Yep.
Oh, is on? Okay.
Oh, that's good.
Yeah, you look right over me like, twice. All right, my name is Simon. My rap name is Top Billion. My album, Let's Make a Movie, is dropping tomorrow. I would like everyone to listen to it. I'm really proud of it. It's a really great project. It's called Let's Make a Movie. Add me on Facebook, facebook.com/topbillion. It's really great music. It's going to be a bunch of videos for it. I already dropped one video for it. The first single is called Incredible Hulk. Watch it on YouTube, youtube.com/topbilliontv. So just check it out. Let's Make a Movie, facebook.com/topbillion.
Cool. Thank you so much, Simon. Yes, sir.
Mastermind, my crew and me, we got a mixtape coming out on Friday called The Iron Team. We're going to have copies on hand, so if anybody's interested, we're going to be passing out copies. Even me, The Iron Team, Friday.
Let's have a forum where we present some of this music. Want to do that? Okay. Well, let's do it then.
Yeah.
Do it next week?
This is just what we talked
Or
about.
the 25th is open? So we'll work that out. Anybody want to play music for next week? Let's talk about that. Any other announcements? Yes, sir.
Wow, what's happening? Loyola Music News. First thing is, you need to be watching Loyola Music News if you want up-to-date information on the latest thing happening in the music world, album releases, album reviews, anything of that nature. Second thing is, if you rap, DJ, beatbox, I'm trying to put together a live show, so see me after the forum when we talk about it.
Cool. Our talent agency is really taking off, too, if anybody wants to join that. Yep.
Every Tuesday, is this on?
There you go.
All right.
Cool.
Every Tuesday night at 9:30 is the No Name Trio, which is a organ trio, highly energetic, highly spiritual jazz music. I'm losing my breath, but come check it out every Tuesday night. Thanks.
David Shirley is one of the best drummers I ever heard or recorded. That guy is great. So anybody else got any more announcements? Yes, sir. All right, then. Anybody else? Oh, sorry. Turn him on. I love you, man.
My band Sun Hotel is doing an in-store at Peaches Records on South Theater. Saturday at 2. It's free. They'll be selling our record there that we just released. And we're also looking for help with some like internet marketing stuff. We kind of falling behind with our email list, and if anybody wants to get some really good hands-on experience with PHP and database stuff, and wants to help with some web marketing stuff, give me a ring or an email. You can just email us at sunhotelsounds@gmail.com.
All right. Thank you so much. Anybody else?
Oh, I got one.
Okay.
We're also playing Musicians Clinic at the Big Top from 5 to 7. It's free this Friday night.
The Musicians Clinic, you remember that's what that lady was here last week about. And we're pursuing that, by the way. We're going to try to do what we can to help those people. So that's coming, and those of you who want to be involved in that event, come see me. We're going to do something in March. It's a big national press conference, and then we're going to actually attach the nursing school to that organization. So we're trying to do some good here with the musicians in town. And also it's going to spread nationally because we're going to attach the sports medical community to the performing arts medical community, and we're trying to get some musicians some help. Anybody else have any announcements? Yes, sir.
All right, I said this last week, but I'll say it again. Not a Professor, new funk band, we're playing Satchmo tonight, Thursday night at, I think 7. And if it's not 7, there will be flyers saying otherwise. But yeah, just book your Thursday for watching us. Yeah.
Thank you so much. Anybody else? That's it? Okay, Josh.
Hi, my name is Josh. I'm actually playing a show this Sunday in Satchmo, conveniently, at 7:30 with the Electroacoustic Ensemble. I'm also releasing an album that day too. I've worked on it since January, and I think it appeals to kind of, I think there's something you'll definitely like on there, so check it out. My rapper name is None Like Joshua, and it's going to be very interactive. We're going to have a thing where we tweet for an unreleased track, and then Facebook like for an unreleased track, and then join the mailing list for a completely different track, and then every one of our subscribers on YouTube get a whole list of songs that are unreleased too. And I'm almost to 400 on there, so that thing's really working out. So if you guys want to hit me up on any of those, feel free to. This Sunday, 7:30, Satchmo's. Thank you.
Lots of music going on here. Okay, let's get started with this forum. And on November the 20th, we're planning this event that has to do with musicians and entrepreneurship and legal and business issues. And this is in conjunction with a law firm here in town, Stone Pigman. And we have 4 representatives from Stone Pigman here today, and they're going to talk to you individually and then take questions at the end. We're going to talk about the event and also about some specific legal issues. So the people you're going to meet here tonight are Scott Whitaker, who's a partner in Stone Pigman, and Robert Broad is also here. He's a business associate of the firm. Leslie Harris is senior associate for litigation. And we also have Elaine Seward here. She's the head of marketing for Stone Pigman. So Scott's going to open it up, so please welcome Scott Whitaker. Thank you.
Thank you, John. It's my pleasure to be here, along with my colleagues, Leslie Harris and Rob Broad, to tell you a little bit more about ourselves and our division of expertise here. I'm a corporate lawyer. I do mostly corporate mergers and acquisitions and general business matters, business entities and formation of business entities, private placements, capital raising transactions, corporate finance, and the like. Leslie has her LLM in intellectual property from NYU, is the current chairman of the New Orleans Bar Association Entertainment Law section, and works in our entertainment law intellectual property group as well as litigation, mainly centering around those things. Rob Broad works in our entertainment law, intellectual property, and corporate group. He also teaches a course in Introduction to Music Business Law and music business. I don't know if the law part is really on there yet. And his practice also centers around entertainment with a particular emphasis on music. How we got here is an interesting story. Leslie and Rob introduced me to Professor Schneider a couple of months ago, and Professor Schneider connected the dots for me in what I've come to refer to as this metamorphosis that is happening in the music business. Some of the people here, I enjoyed the announcements because y'all could teach me a thing or two about this metamorphosis. Y'all are really on the ground floor of a sea change in the music industry, in the music business, where the musicians, artists like yourselves, are being transformed from tools of record companies and producers and commodities of those types of businesses into entrepreneurs and business owners yourselves. And it's the technology, the innovations in technology that have really made this possible. Whereas it used to be that it would be prohibitively expensive to have a recording. Now, with digital recording and the quality of digital recording, artists can make their recordings relatively inexpensively. And then you have the digital distribution channels, the aggregators, the digital distributors, and then you've got ways to make your music known through texting and email and social media like Facebook and Twitter and all of that, where, and because you don't have the record company taking the lion's share of the revenue, if you get digital downloads of a few tens of thousands of, from a few tens of thousands of fans, artists today and in the coming years can make more money from that than the artists that you have familiar names from the past who had record deals. So, I didn't really know all this until a very short time ago, and when I learned about it, I became excited because that's opening up a whole new industry, and especially here in New Orleans and in this region where there's so much talent, so many musicians here. So, obviously it's an opportunity for lawyers who practice in the area, but also it's a need that needs to be filled. So we wanted to be a part of filling that need. So we came up with the idea of a music business conference, and we're putting that together for the November the 20th. It's a Saturday. We've handed out the working draft of our flyers here to everybody here tonight. I think Elaine's got more. If you want to take more, please do. The conference, is scheduled for 4 hours. We're going to get into some in-depth discussion of not just the legal aspects of the music business, but also the business aspects of it as well. Not just lawyers, but we're also going to have some artists who are also participating in it. Professor Schneider is also going to be a key member of the program. It's going to be free to students. I don't know, the price of admission for others is being discussed, but y'all are welcome to come. Tell your other students who are interested to please also come to that forum. We're going to go into today, and this is not all about promoting the forum today. We're also going to have today some content that we're going to go into more in depth in the forum. We're also interested in preparing for the forum and hearing what you all would like a music business conference of this nature to address. I believe in not telling the audience what we think the audience wants to hear, but we are soliciting y'all's thoughts and suggestions as to what we ought to cover in that music business conference on November the 20th. So please do. We're going to have a Q&A after this. What we're going to do is talk a little bit about some of the topics that I and Leslie and Rob are going to discuss at on November 20th in the forum. We're going to get into these in a lot more detail. We only have 1 hour tonight. I understand that this is a course for you all, so we're not going to go over that hour. But we do want to hit on some of this content to pique your interest as to what we're going to get into in a little more detail at the forum. What I'm going to talk about is business entities. And in the context of a band, the music is the center of attention. The band members want to get together and they want to make music and they want to get a reputation and they want to get a fan base, and they're all about the music and coming together. And it's not usually thought of as to whether we should incorporate our band or create a business entity that is going to be the band. but I'm suggesting to you all that when a band gets together and decides that they want to make music, and they go out and pick a name and go play gigs and buy equipment together and do the things that a band does, well, you've made a business entity. You've made a business entity by doing that, and yet that business entity that you've created is a general partnership. It's called a Louisiana General Partnership. The definition of a Louisiana General Partnership from the Louisiana Civil Code, it is a juridical person distinct from its partners, created by a contract between two or more persons to combine their efforts or resources in determined proportions and to collaborate at mutual risk for their common profit or commercial benefit. Okay? Now, that contract that's discussed here does not have to be in writing. It just has to be an agreement that the members of the enterprise will combine their resources and collaborate at mutual risk for common profit or commercial benefit. That sounds like a band, doesn't it? So if you don't form another type of entity and you wind up as a general partnership, well, is that bad or is that good? What exactly does that mean? Well, there's a few things that people should be aware of when it comes to the law governing general partnerships. The first is that in a general partnership, each member has equal ownership of the partnership, and equal right to the profits of the partnership, equal right upon the dissolution of the partnership to the assets of the partnership. Sometimes, in a band or other business enterprise, it's decided that the one person would have more or less than their straight by heads ownership. If that's the intention, then you're not going to get that intention recognized in a partnership. Every partner in a general partnership also has an equal vote. It's one vote per member. Sometimes one person in the partnership is supposed to have more power and more authority in the say-so of decision making than the others. Again, if you don't have it in writing, you don't think about these things, everybody's got one vote. Every partner in a general partnership also has personal liability for the debts of the partnership to the extent that the partnership can't pay those debts. So if there's some sort of a debt that the partnership has, some sort of a lawsuit, for example, that the partnership gets sued for, the band in this scenario gets sued for, and the partnership doesn't have assets to pay that, then every partner is personally liable for his percentage, and that's by heads. Every partner has an equal share of those unpaid liabilities, even though you might not have had anything to do with the circumstance that gave rise to those debts of that general partnership. Every partner in a general partnership has the authority to bind the partnership as well. So in matters involving the ordinary course of business, what's the ordinary course of business? Agreeing to play a gig, for example, agreeing to maybe buy equipment or some other obligation that one partner may undertake on behalf of the band. Legally, that partner, if it's in the ordinary course of business, could bind that band and that partnership and bind thereby each one of those partners as well. Every partner in a general partnership also owes a fiduciary duty, what they call a fiduciary duty, to the partnership and all the members of the partnership. And what that means basically is that you've got to be loyal to the partners in that partnership, the band and the band members. And if you go do something that is prejudicial or harmful to the partnership, then you could be held liable for breaching your fiduciary duty. So leaving the band, playing with another band, are these kinds of things breaching your fiduciary duty? It's pretty easy to see how disputes among band members can arise. I'm sure you all heard of situations like that where disputes have arisen that could be a legal liability there. There's also rules on when a partner can withdraw from a general partnership. Generally, a partner can withdraw when at any time, as long as it's not prejudicial to the partnership. And when a partner does withdraw from the partnership, that partner, by law, is entitled to be paid the value of their partnership interest. So you can see just from that little list of things that if you default, if you don't think about it, if you don't do anything about it, and you default to a Louisiana general partnership, there are rules that will be imposed on you and on your band members that you might not like or might not want. It's much better to think about this and plan for it and get it in writing. You can do things like either formalize your partnership, form a limited liability company, or even a corporation or a limited partnership. There's a number of different entities which we don't have time to get into this evening, but we'll get into in more detail at the conference. The other thing I'll talk about at the conference is raising money. In the United States, if somebody asks somebody else for money, and the person who gives the money gets back what's defined legally as a security, then the federal securities law applies, as well as state securities laws apply. And a security is not just a share of stock. It can also be a promise to pay you back with interest at a certain time. These are the same laws that put people like Bernie Madoff in jail and all of that. You wouldn't think that they would apply to a band trying to raise money to do a recording. But whenever you're raising money, you have to think about whether or not you're triggering the securities laws. There's new ways that I understand bands are using now to raise money, such as this Jumpstart or Kickstarter, Kickstarter.com, where it's not raising, you're not selling a security, but you're selling a product, like a picture of your band, with the autograph, or a copy of your CD, and all of that. These things are interesting and legally can be legally intricate, but you definitely want to make sure that you stay on the right side of the law when it comes to raising money, and especially need to think about that if you're promising to pay somebody back with interest at a certain time in the future. That's about all the time I've got for my segment today. I'm going to turn it over now to Rob, who's going to talk a little bit about some of the copyright issues that we'll deal with in the forum. Rob?
Well, I almost feel like, under John Snyder's tutelage that you could probably give this lecture to me, that he's probably pounded copyright into your head so hard. You have the Copyright Act of 1976 haunting your dreams. So a lot of this will probably be review to you, and if it is review, that's really good, because that means you have a good foundation. It's my view, and I think shared by Professor Snyder, that copyright is pretty much the basic and foundation of how songwriters and how many musicians, earn their money and make their income. So today we're going to kind of go over the foundation, the basic legal principles of copyright. Then I think during the seminar, we'll address more of the nitty-gritty details and how, the process from the song's creation to the song being put in a movie to having a record deal, how you make money from this foundation. So basically, is your foundation going to build you a shack, or is it going to build you a mansion? And hopefully with, the understanding of these principles, you'll be building a mansion on top of your foundation instead of just a humble shack. So what is copyright? It protects authors and original works of authorship. Things like literary works, dramatical works, musical works, motion pictures, and audiovisual works, those things are copyrightable. One of the common questions I get in my class, or common things that are said to me, is, I got to make sure I copyright the title of my album. I need to copyright this and copyright that, without any real understanding of what it actually means to copyright. Copyright becomes a general usage term for any kind of IP. I invented this, I have to copyright it. No, what you're doing is you probably want a patent for that. So it's important that, if you're going into business also, and that you're going to be representing artists, you actually understand what what a copyright is and when you need a copyright and what in fact is copyrightable. So when we're dealing with in the music industry, we have two essential copyrights we're talking about. We're either talking about the musical work copyright, which is the melody and the lyrics, or we're talking about the relatively new sound recording copyright, which is the recording of the melody and lyrics. So you get a magical set of rights when you have a copyright. This is in the Copyright Act. I'm sure you can recite these rights to me back and forth. The right to reproduce the work, the right to distribute the work, reproduction and distribution. For instance, if you're if you're making copies of your recorded version of the song and then you're selling it to the public, whether it be on a CD or digital distribution, that's reproduction and distribution of the work. That's an exclusive right. We're gonna get into some exceptions in a minute, but generally the exclusive rights means you can do it and no one else can. And if they want to do it, they're gonna have to pay you. They get your permission and pay you. That's where all the money comes from. But again, we'll get into that later. Public performance is also an exclusive right, at least of the musical work. Public performance, we're talking about radio, we're talking about television, we're talking about nightclubs, whether your band that you wrote the song is playing it live or another band is playing it live somewhere. That's a public performance of the musical work. Or it could be a DJ playing a recorded copy, the MP3 or the CD. That's also a public performance. We have derivative works. Oftentimes that's a translation into another language. For instance, in the movie Mulholland Drive, there's a Roy Orbison song called Crying that's sung in the movie, but it's sung completely in Spanish. It's still Roy Orbison's musical work, but it's a translation. So that would be an example of a derivative work created from the original. Public display. This doesn't come into play as much with music, but you could have public display of a musical work. There could be in a museum, you could have the original lyrics, by John Lennon framed in a museum. That would be a public display of, lyrics, which is part of the musical work. Now, sound recordings have a very limited public performance right. It might sound exciting because they get mentioned separately, but in fact, what it gives them is much less than the musical work copyright holder. They have the exclusive right to publicly perform sound recordings by digital audio transmissions. That's like satellite television, XM radio, that's webcasting. So while the musical work copyright holder is paid for all public performances, such as, we're talking about radio, turn on your car, you turn on 93.3, that's a public performance that the musical work copyright holder is paid for. Songs on television, the musical work copyright holder is paid. If songs streamed on the internet, the musical work copyright holder is paid. The sad plight of the sound recording copyright holder is they're only paid for those digital audio transmissions. Now, it's important to remember that in those digital audio transmissions, the musical work copyright holder is also paid. So pretty much, if you own the musical work copyright, you're a winner in all levels. If you own if you own the sound recording copyright, you only get paid in a limited, you only get a limited slice of the pie. But currently, Congress is discussing changing that with the public. Now that I'm blanking, the House Bill 848, the Public Rights Act, where they're trying to get equality across all mediums, where sound recording copyright holders would get paid also for television and radio. It hasn't happened yet, but it's been a battle for a long time. Frank Sinatra actually fought for that cause a while back, so you know how long it's been going on. Again, we were talking about some exceptions. We talked about those exclusive rights. They're kind of like your magic, like a set of magic beans. Like you can use them, no one else can, and from those beans come like these crazy powerful rights that you and you alone can control. And from those rights, you can earn a whole lot of money. So it's like a superpower you have, except where every superhero has some weaknesses, has their kryptonite. There's some exceptions to these super powerful exclusive rights. For instance, the right to reproduce and distribute. There's such a thing called a compulsory license. I'm sure everyone in here has heard the term compulsory license. This essentially applies to cover songs. If you want to do your own version of someone else's musical work, you don't have to get permission from the song's writer or from whoever owns the musical work copyright. Because again, oftentimes a songwriter transfers their rights, or at least parts of their rights, to a music publisher. Or you can transfer your rights to pretty much anybody. So it's not always the songwriter who continues to hold those rights. One of the most common questions you'll get if you get into the music industry is, do I need permission, to cover this song? Well, the answer is no, you don't need permission, but you have to pay the statutory rate. The rate set by the Copyright Royalty Board is 9.1 cents per song to do a cover of the song. And again, if you do a cover of a song, it doesn't give you the right to change the song. You can change it to conform to whatever style you're doing, but you can't change the melody and you can't change the lyrics. If you do that, it's no longer a compulsory license. You'll actually need permission to do so. And it's not 9.1 cents anymore. You have to get permission and negotiate a rate. We just talked about the sad plight of the sound recording copyright holder and the limit of the public performance right. So their public performance rights are very limited. So the way they make money from their copyrights is much more limited than that of the musical work copyright holder. So when are you protected? When does the copyright, when do those rights vest? It has to be an original work of authorship. So if you stole someone else's song, you're not going to be able to get a copyright in it. And it has to be fixed in a tangible medium. Tangible medium doesn't have to be anything fancy. You can write, if you're good with notation, you can write the music down on the back of a cocktail napkin. Then you have a copyright in the song. You can, I could record it into my iPod right now. I could sing. I can't sing, and I don't have any song ideas. So, but if I did, I could record them into my iPhone right now, and I have a copyright in that work. So, I hope none of you would steal it. Not that you'd want to if you want to make any money off it. Or you can do it in, do it in a studio, in $1 million studio. All those ways of recording a song. Once you record it in any of those mediums, you have a copyright. How long does it last for? It lasts for your lifetime. So you won't have to worry about the protection lapsing during your life. It goes lifetime plus 70 years. So even your heirs and your estate will be benefiting from your works long into the future, long after you're gone. Thankfully, the notice is no longer required. Previously, before 1978, if you didn't put the Circle C or the Circle P, there wasn't a Circle. There wasn't a Circle P in a sound recording copyright back then. But if you didn't put the Circle C to give copyright notice, you didn't have a copyright, and that flaw was fatal. So you can imagine how many people who didn't have knowledge of the music industry were failing to get their copyrights protected. But at least in those days, everything was put out by a record label, and there were big publishing companies. So you'd hope that their business department knew enough to put the copyright on it. But can you imagine these days with everyone doing their own, being their own label, being their own publishing company? If you don't know that business side of it, if you didn't know that business side of it and didn't know enough to put a Circle C in your copyright notice, can you imagine how many people would be regretting their lack of knowledge today if that law was still in effect? So you might be asking, if I have the copyright, once it's on a cocktail napkin, as long as I save that napkin, I'm all set. I'm protected, right? Well, it's unfortunately your magic superpowers aren't fully encompassing. It's a good idea to register anyway, because you get some benefits when you register. You still have protection. People can't come and take your song as long as you have the copyright. You can take action against them, but before you can take action, you have to register anyway. So you might as well register in the beginning, because you can't file suit for copyright infringement without being registered. Other reasons you might want to register, there's a presumption of ownership and validity in the copyright if you register within 5 years of publication. Publication is distribution to the public. And the big hammer to hit people with is statutory damages. That's really the reason to register. Because every instance of infringement, the statute says is worth between $750 and $30,000 per work, and $150,000 for willful infringement. It's these statutory damages that are bankrupting grandmas everywhere. This is how the IRA and the other big music companies make the money. When you see those lawsuits, someone downloaded 2 songs and they owe $60,000. You wonder, well, how the heck is that worth $60,000? All they did was download it. They would have bought the CD. They would have at most paid a ridiculous $20. But I can't see how that's worth $60,000. Well, that's because of statutory damages. You don't have to prove that they sold $60,000, they downloaded $60,000 worth of material, or that they allowed others to download from them $60,000 worth of material. That's why it's so advantageous to register and have these statutory damages available, because it essentially ensures a windfall to the party, possibly the party who was infringed against. Even if they only sold, even if they only downloaded 1 song from you, you could get a judgment of $30,000 in your favor, even though your actual damages, you didn't suffer anywhere close to that. It's easy to register. You can do so online. You can register your sound recording and your musical work in the same form ECO online. It's only $35. So you really have no excuse not to register. It's the prudent thing to do. When you're talking about, if you're in a group and you're in a band, you're writing songs, or even a lot of my students are aspiring rappers and producers, and they want to know who owns what. I did the beats and the music behind on the track, and I had 3 guest rappers. I own 50 per. Okay, let's go. Yeah, 3 guest rappers, and I did the production. So I own 50% because that's industry standard, right? Well, if you don't have an agreement that says otherwise, all contributions are equal. The law says everything's equal. You each own an undivided quarter interest in the copyright. Again, we're saying quarters because there's 4 parties involved in the situation. And it doesn't matter how much you contributed and how little the other party contributed. You're all equal in the eyes of copyright law unless you have an agreement saying otherwise. And that's why it's important before you get into the studio that everyone signs, or when you get into the studio, to sign a split sheet. Bless you. Which pretty much details who owns what. I wrote this verse, and we're considering that 25% of the total song, and we're going to split the income. We're going to split the income evenly. Or if hey, I wrote the hook and I did the beats, you only rapped on one verse. Maybe I own 75% and you own 25%. And it's really up to you. But if you want to make sure things aren't split equally, if you put more in and you want to make sure you're getting your share of the income, what you believe to be your earned share of the income, then it's important to have those agreements up front. Because later, if you don't have those agreements, you can bet the guy who wrote only one verse is going to claim that he also wrote the hook, and he came up with the guitar's melody. Because that's the nature of the music business. If you don't have it in writing up front, it's going to come back to bite you later. So it's important to put your writing shares up front and also the publishing shares. For every dollar made, at least as far as public performances go, it's 50 split in half. There's the writer share and the publisher share. So unless you put that up front, how that's going to be split, the writer share and the publisher share, everything's going to be split equally. And if you're doing the lion's share of the creating, having an equal split is not what you're probably not what you bargained for. Okay, and I think when we do the conference, we're going to talk about the nitty-gritty of how a song from creation to success, all the licensing deals that are available, and the importance of licensing, and what exactly you're licensing, what are you giving away. When you sign a license agreement, do you realize what rights you're giving away and how valuable those rights are? We're going to talk about all those things. But I think this is a good primer, good starting point for today. And up next is Leslie Harris is going to speak about some trademark and service mark issues. Thank you.
Good evening, everyone. Can you hear me? Yeah. All right. I have some low-tech show and tell, and I want you to yell out the trademark and what it represents. So number 1, McDonald's. Can you guys see this? Paris Hilton. Okay, for all you girls out there. There we go.
What was it?
Or for all you guys out there, too. And then finally, because we're talking about music, what is this? Okay, so you guys can see that the importance of trademarks. An image like this brings to mind a specific source, and it identifies a specific maker of something. So what is a trademark or a service mark? A trademark can be a word, a name, a symbol, a phrase. It can even be the color of a high-heeled shoe. And it serves as an identifier of the source of goods and services. So McDonald's, of course, is hamburgers and fast food. The Rolling Stones is music, Christian Louboutin, shoes, and Paris Hilton, and that's hot. I don't know what exactly she does, but it identifies her. So as a technical point, there are 2 flavors of trademarks. There's a trademark, and then there's a service mark. A service mark is used to identify services like music. So when you register your band's name, you would register a service mark. A trademark distinguishes words or names and symbols that's put on a good. So for example, Lady Gaga has registrations with the U.S. Patent and Trademark Office. She has registered her name as a service mark as providing entertainment and musical services. And she has also registered trademarks Lady Gaga for various things like perfume, posters, TVs, well, not TVs, but T-shirts, maybe TVs, stickers, and things like that. I want to talk to you guys about the importance of registering your trademark. I know a lot of you guys are in bands. Who has a registered mark for the band? Can't really see. Has anybody applied for a registration for their band's name? Yes? No? No? Okay, well, you should, and that's why you should come to the conference, because we'll talk about the details of how you register a mark. And it's very easy, actually, and not that expensive. So you guys should come, and we'll hammer out those details. So let me just talk quickly about how trademark rights arise. They arise by use of the name or mark, and they also arise by acquired secondary meaning. That means that the public has come to associate a certain name with a good or service. So I say Lady Gaga, and you know that it's music. I say McDonald's, you know it's fast food. But you don't have to register your trademark in order to have rights in the trademark. For example, Lil Wayne does not have a trademark for his name, but he has become so well known as a rapper that it's possible that his name has acquired secondary meaning. You hear Lil Wayne, you know he's a rapper. By contrast, Britney Spears has registered her name, and she's registered it because her name has come to become associated with music and pop, but also because her name has an acquired secondary meaning, meaning that you guys all recognize the name Britney Spears and you associate it with pop music or whatever Britney Spears does. So you don't have to register your band's name, but it is important. And there are reasons why it's important to register your band's name or your own rapper name as a mark. Some of the reasons why it's important is that when you register your mark, and it has to go through a process, and again, we'll talk about the examination process at our conference, but when you register your mark and you get registration, there's a legal presumption that you own the mark. So that means when a third party comes and challenges you and says, no, I'm the real Lil Wayne, you have that certificate that says, no, I'm Lil Wayne, I've registered my mark, and there's the presumption that you own it. The other reason for registering your mark is that it provides notice to third parties that you're using the mark. So again, for example, your rapper name might be Lil Wayne, and you go to the Patent Trademark Office website and you check to see if anybody else has registered Lil Wayne, and you see no. But if your name is Britney Spears and you check the Patent Trademark Office and you see that Britney Spears is there, you can say, you know what, I can't register that. You're the third-party user, and she could come sue you for a lot of money. You can also, by registration, stop a band from using a confusingly similar mark as yours. So there was the Glee episode last week that was the Britney Spears episode, and the girl said her name was Britney S. Spears or whatever, and yeah, exactly. And so that would be a confusingly similar mark, and you could stop someone from using that mark. And finally, and very importantly, not only does registering your mark prevent third parties from using the mark, but it also prevents departing band members from taking the mark and using it. So if you remember a few years ago, Guns N' Roses got into a battle about who owned the name Guns N' Roses. Axl Rose said that he owned it, and Slash said that he owned it. And so there was a legal battle over that. Recently, Ozzy Osbourne, too, got into a legal battle about who owned the Black Sabbath band name. So we will talk at the conference about how to divide those rights up, how to decide who owns the mark, and what you should do to protect yourself from departing band members. Now, you need to be aware that registration is not the only thing that protects you. So let's say you apply to register your name, you get a registration certificate, and you stop using your mark. You can't do that. You have to have some use of the mark in public and some continued use of the mark. Otherwise, the mark can become abandoned, and the Patent and Trademark Office will say, you know what, is abandoned, anybody can use it, and you'll have to fight over that. Now, as I talked about before you choose the name of a band, or if you have a band and you have a name right now, you should decide whether or not you're going to keep that name. And one of the reasons why you should, and what you can do, is to check the U.S. Patent and Trademark Office website to see if there's somebody else who has the same band name or the same artist name as yours. It's a very simple search. You go on to uspto.gov, and there's a search area, and you just type the name in, and you can see and check to see if there's any other party using that name. When you talk about with your band members, or think to yourself what your name what you want your name to be, you should think about using distinctive marks, and that's names that are not necessarily associated with one band member's name or where you're from. So, for example, you'll probably more easily get a registration for a band called the Ting Tings than the Dave Matthews Band, or Eminem versus Marshall Mathers. Completely arbitrary and fanciful names are more easily registered, and the more distinctive the name, the less likely it is that some third party already owns it and that your application will get kicked back. Not only should you check the USPTO's website, you should also check iTunes, Google, and performing arts societies to see if some other party has your name before choosing your band's name or trying to register it. So what is the point of all this registration and getting your name out there? First, registration and choosing a name, a distinctive name, will allow your fans to find you. Registering your name also prevents other musicians from using similar or confusingly similar names. And the final thing is money. You want to be able to put your name on a t-shirt and sell it to your fans. You want to be able to put your name on a CD and sell it to your fans and not have some third party out there put your name on a t-shirt or a CD and sell it. So that's the importance of registering it. And if you guys have questions later, I'd be happy to answer them. Thanks.
Thank you, Liz. Appreciate it. So we have about 10 minutes for questions. And before we do that, I want to introduce Gavin and John here from the Law School Society down at the law school down the street. Y'all want to stand up? So John is president. Gavin's the president of the Law School Society, and John's vice president. And we have our EU here too, Business Affairs. So now y'all want to ask questions of these ladies and gentlemen. Y'all come up on the stage. We'll get you a chair, and you can sit here and answer questions if you want. So that idea of the trademark and the service mark, of course, is going to make
let us
merch.
have it.
I'll get you a chair.
Thanks.
Leslie, you can.
Oh, thanks. You guys are
Is this gentleman?
gentlemen.
I'm insulted you
Here,
chose
please.
Scott's chair, not the one I gave you.
There you go. All right. Anybody have any questions? You know everything you need to know, yes, sir.
In reference to compulsory licensing, let's say you want to do a cover of a band song.
Sure.
Where do you go to find out, well, you know who owns it, but where do you go to pay? What's that process?
Usually the Harry Fox Agency is the first place you want to go. They handle most of the licensing for cover songs. That's usually how it works, although as an independent artist without a label behind you, the process is a little more burdensome, because often if you're with a big record label, you'll pay for every copy sold, 9.1 cents or less, depending on the deal you can negotiate, for every copy of that song sold. If you're an independent artist, you're going to have to pay in advance, a certain amount, because they want to make sure you pay, basically. So you have to pay upfront in advance, maybe at 100 copies or 1,000 copies. They have different licenses. You're going to have to pay at least upfront and then make additional payments if you sell more, sell more than your initial payment. But the Harry Fox Agency, they have a website. That's the place to go.
Sir.
Does that only apply to if the artist is covering the song wants to sell that song? Because I know plenty of bands that
No.
songs and give them out free. Is that violating anything?
Yes.
Yes, because that's the right. We talked about the 6 rights. The right to distribute isn't tied to necessarily for sale, Because if you think about it, if you do a great version of that song, maybe I no longer need to buy the song, right? You're giving it to me for free. I like your version a lot. Why should I pay? Why should I pay for the original artist, one who wrote it, if you're giving it to me for free? So so the answer is no, you can't. Yes, you're violating copyright if you give it away for free, and that's kind of the explanation of why that's not allowed.
The interesting thing about the band thing is everybody in here is in a band, and what you don't know is if you don't have an agreement, then you're assumed to be in a general partnership. I thought that was fascinating. So you have obligations and responsibilities whether you like it or not. That's an interesting problem to have. Sir?
Is there a specific format for writing out physical logistics of a band? Like if we wanted to make it different from just the default partnership, or if it is like simple statements like player A has stepped back for some of the band signed here.
It can be just that simple, or it can be 35 pages of legalese as well. But if you have an agreement that's different from the equal voting, equal authority, equal split, then it ought to be in writing. If you don't have the inclination or the resources to go to a lawyer, then do your best, but put it in writing and get it signed. That's the main thing.
Anybody else?
Yes.
Can't see you.
Sorry.
Yep.
I don't know if you're doing questions for the forum on the 20th, but I'd really like to see a comprehensive dialogue on the character of a work as defined in the Section 115 of the mechanical license, because I've seen a lot of variability in what is a character of a work and what constitutes faithful arranging or becoming a derivative. I don't know if you can make like a comprehensive example list, but that would be great.
So you're saying whether it falls under the compulsory license or whether you actually need permission from the whoever owns the musical work copyright to perform whether it's a cover or whether it's not really a cover, whether you added something new to it?
Yeah, there's a whole budding genre of jazz players out there, like Brad Miller does a cover of exit music for a film, fantastic Radiohead song. Other examples where they don't use lyrics, they don't really keep the melody, but they're still covers, and it's this really nebulous. It's not as straightforward as same lyrics, same melody, same therefore the character's the same. I'd like to see a little bit more dialogue about it.
Okay, we'll definitely look into that. I think the idea is, though, you want to be careful. If I know the practice, especially major labels, if there's any slight change, they go the extra mile to make sure they get clearance and don't rely on a compulsory license. For instance, I know of a specific example that Jason Mraz covered was a Lionel Richie song, the lyrics or something like "Dancing in the Streets." And, the song was a faithful cover all the way, same melody, and he just changed the lyrics to "Dancing Between the Sheets." And with that simple change, they felt it wasn't good enough to just do a compulsory license anymore. They felt, at that point, it was, they had to get clearance from the music publisher, to make those changes. So even a small, even something that seemed like a real small change, that seems like, well, it's exactly a cover, just, a throwaway line at the end of a song, it was enough. At least that's from the risk perspective, is you want to make sure your bases are covered.
But we will get into it in more detail at the conference.
Josh? Jack.
Make notes.
Yeah, as Scott was saying, we're happy to take
Make
suggestions.
notes, yeah.
So, sure, if that's something people are interested in, that would be a great topic to go over. There's a lot of legal issues, especially in the hip-hop community, with who owns what, and the licensing of different, especially samples, is a huge issue that you have to go over time and time again, because people are under the false impression that if you only take, if I take 2 beats or less of the song then it's fair use. Well, the law doesn't, there's no specific amount of notes or amount of beats or amount of time that designates fair use. Each case turns on the facts. So yeah, I think the Creative Commons is a good time.
We'll do that. Gavin.
I don't know if this is something that the law firm handles or if it's left to the accountants, but discussing the new Louisiana sound recording tax credits and live performance tax credits, and I don't know if a lot of people here need a statutory minimum for the spin name to receive the tax credits, but I think a discussion of that for future use would be highly beneficial.
We can do that. It's
Yes,
$15,000
definitely.
aggregate in a year. So if you spend more than $15,000 in Louisiana recording music, you can get 25% of that back in a check from the state. So
And
you
law
could
firms do
aggregate
that work.
your stuff. You could have one production company that takes 4 different bands that has $4,000 each, and you can get back 25% of that money. In fact, we did that for our studios. We got 40% back for that infrastructure building because of the film tax credit. Anybody else? By the way, when Rob is talking about how the exclusive rights, that you get this exclusive rights, it's interesting on the one hand they are exclusive, and on the other hand they're anything but exclusive because we all violate them all the time, every day. 2 billion songs a month being file shared, we're violating those exclusive rights. So it's interesting because you have them and you can monetize them, but now you've got to figure out a way to deal with the unauthorized uses. And there's one, Patrick, one of our former students, has taken the position, we should all authorize more. Authorize away. You have the right to authorize it, so authorize it, rather than have people go behind your back stealing your music. It's an interesting point of view. Anybody else? Yeah.
Maybe something to cover with the NAMA, the government's copyright website.
Sure.
I
Sure, we can.
They are behind.
No, I tried to register a song and didn't ask for lyrics or a sound recording. I and I paid money, and I don't even know if I
Okay, yeah, we can cover the technical. We'll be more high tech than we are today.
Right.
I don't really understand why the government wants to make it so clear.
Because everything with the government is difficult.
Right.
Okay, anybody else? I don't see any hands. So please thank our guests for coming. Thank you very much.
All right. Thank you.